Our speaker is from the University of Aberdeen to say how much the University of Baltimore values our partnership with the University of Aberdeen, which has been going on now for 23 years. We're about to have our 25th anniversary. And as someone who just recently celebrated his 25th wedding anniversary, I can tell you that it's an occasion for a party. So I think we should start planning for that, and I hope that you will take back to your colleagues in Aberdeen the very warm feelings of solidarity that they have with the faculty of the University of Baltimore here. With that, I introduce Michael Hayes.
Thank you, Tim. And thank you very much all for coming for the kickoff of the 25th anniversary celebration. And the John Sumner Stead presentation by Professor Sarah Bleichner. Sarah has been at the University of Aberdeen since January 2008 very distinguished lecturer there. She has her degrees from the University of Aberdeen and an LLM in International and Comparative Law from Tulane, and loved New Orleans so much she stayed and practiced law there. Sarah's a member of the bars of Louisiana and Nevada, so she knows where she wants to practice law if she comes to the United States again. Her research includes criminal justice and human rights, which will be related to the topic of her talk, comparative law, international law, and public international law. And I'm very pleased to introduce Sarah Bleichner, who will speak on parental liability for crimes by children. Sarah?
Well, thank you very much, everyone. I was going to sit because I was told it informal, but I'm being blinded by that light, so I'm probably just going to stand. Thank you very much, Tim, for your kind words, and I'll certainly take those back to Aberdeen. We also very much value the opportunities that this creates for both of our schools. So I'm very pleased to be here, and we're always very happy to have faculty and students coming to us every summer. Thank you. I'd actually like to take the opportunity to also thank everybody for being very welcoming, Kathy and Gloria for their help and welcome, and in particular Michael, who has been incredibly helpful, making sure that I know where I am, where I'm going, what I'm supposed to be doing, and getting me from the airport and all of those, helping with all of those things that when you come to a new city are incredibly hard to deal with and stressful. So he's made this a very pleasant experience for me, so thank you very much for that. So my topic today is what I've described as a culpability gap, and it's the question that occurs from time to time, particularly in the media, in public discourse, about whether or not parents could be held liable as principals for the crimes committed by their minor children. And it's a topic that has not really been considered particularly much in Scots law, which is one of the reasons I'm writing on it. But it also means, of course, my presentation today is going to be very Scots law focused, and so I apologise for that, but I hope that you find that in itself interesting to see a comparison with a different jurisdiction. To that end, I want to start off by explaining a little bit about how juvenile justice works in Scotland, because I believe that it's quite a different system to what you see in the rest of the United Kingdom and in the United States. In the early 1960s, it was felt that there was a problem with how juvenile justice was being delivered in Scotland. And there was a major inquiry investigation by a judge called Lord Kilbrandon and a committee under him. And in 1964, they produced a report which basically found that children who are offending are just as much in need of care and protection as children who are being subjected to parental abuse or other forms of neglect. And of course, in many cases, those children are in both positions. So children that are offending have also been subjected to chaotic and difficult lifestyles at home. In 1971 then, a new system called the Children's Hearing System was introduced, and basically decisions are made, children are referred. Someone just hit the enter key for me, please, to move it off. There we go. Okay, I've broken all my own rules with PowerPoint here. There's far too much information on that page, and it's also kind of an ugly slide. But anyway, these are the grounds in which children are referred to the children's hearing system. The system, therefore, as you can see, one of the grounds is that the child has committed an offence, but in fact most of the grounds are to do with care and protection issues. That the child is beyond the control of parents or carers, obviously often goes along with having committed an offence, but the child is some way at risk or a victim or likely to suffer serious harm to health or development. That's the ground on which most referrals come, that the child's likely to suffer serious harm. When a child comes to the hearing system, there's usually a lot of social work and other agency involvement. More often than not, they're referred by social work rather than the police, but that can happen too. But where this is different to normal juvenile justice is that when a child comes to a hearing, it's 3 members of the community that make a decision about what should be done in the best interests of that child. Whether the child is an offender or whether the child is simply being neglected or subjected to some other kind of mistreatment. So it's 3 lay people. There is a clerk who can give legal advice on procedural matters and that type of thing. Everything's done in the open. The child listens to everything that's discussed. There's some exceptions. If the child's too young and things are going to be discussed about the parents, it wouldn't be appropriate for the child to hear, then the child might be excused. But the theory is that the parents or people who are in local parentis and the child should all be present, and all the discussion and decision making is done in the open. There's no retiring to discuss it. Each panel member makes an independent decision there and then, and the majority decision is the one that's carried out. I know Dave and I had a quick discussion about this, and he was kind of a bit horrified by some of the perhaps lack of procedural safeguards here. The child is only usually represented if there's a likelihood that the child's liberty will be taken. So in a lot of cases, the child may not actually have legal representation, and that's something that we're also looking at as to whether or not that is a good or bad thing. The idea was that this was not a court process, but in reality a child who agrees to the grounds for referral, who's committed an offence, ends up with a criminal record, and so it has it has consequences. The record may be spent after a certain number of years, but it depends what the offence is. Okay, so that's kind of just to sort of give the background that our system is really looking at the family as a whole, is looking at the fact that an offending child is often a victim themselves, is looking at ways in which culpability is reduced on the part of the child, moral culpability, if you like, is reduced on the part of the child because of other circumstances particularly in their home life. So it sounds like a good system and it works for a lot of children, but obviously there are children who offend in such a serious way that this is not the system that's felt appropriate. And so children who are accused of murder, assaults where someone could have died, serious sexual offences, these are all tried in the adult courts. Obviously that's the minority of cases, but those will still go to adult court. And when those cases come up, the public discourse seems to be that something should be done about the parents. Late last year in Scotland, at the time of the attack, it was 2 14-year-old girls and a 13-year-old boy stripped, beat and abused another 13-year-old girl, videotaped it, and had a good laugh about it, and said things like this is like Resident Evil computer game, and didn't take it seriously at all, even after the process was fairly far down the line. And of course the public outcry, the media discourse was that something should be done about the parents. And in fact, in the case, the judge in his sentencing remarks showed that he was reducing the sentence based on the fact that these children had all been exposed to, in one way or another, chaotic lifestyles at home, drug and alcohol misuse, physical abuse and violence in 2 of the cases, and a catalogue of other behaviours that their parents had displayed which were felt to have had an impact on how they had come to this situation where they had committed the offence. In other words, those children were less morally culpable because of the actions of their parents. And so the question that the newspapers like to ask is, why don't we do something with the parents? And that's the question that I decided that I would try to answer. So there are 2 aspects to it. First of all, looking at theories of participation in crime. So is there a theoretical underpinning to assign that type of liability in criminal law? And then obviously questions of whether or not it's actually desirable to do so. Is it in the public interest to assign liability in that way? So the question then is, are there any theories in Scots law or any other system that would underpin holding a parent liable as a principle for the act of their child? In Scotland, we have the doctrine of concert, which covers most of the types of participation liability that we would normally associate with criminal law. What we call art and part guilt, which is aiding and abetting. I hate to say art and part, if I say it too fast it's like runs into one word, but art and part guilt, which is our aiding and abetting. Conspiracy and joint enterprise, those types of participative liability. None of those really, and so I won't go into them, but none of those really provide a model for parental liability, because in all cases there has to be some kind of agreement, meeting of the minds, and or physical presence at the act, which in these cases is not applicable. The one exception is perhaps a theory of joint enterprise, where a person, it's foreseeable that a certain consequence will occur even though the person doesn't know the consequence will occur, and that really would apply to cases where, for example, a child has been bullying another child at school and a parent either condones that or even sometimes encourages it. In that situation, it's arguable that the parent, although they may not expect the child specifically to assault the other child, the parent might say, you might say that it was foreseeable that it would happen, and that by using encouraging or inciting language, for example, that a parent has left themselves open on a joint enterprise theory to liability. However, I think more importantly for the majority of situations that we'll be looking at, it's really the law on omissions and failures to act that becomes more relevant to the situation that we're considering. Because generally speaking, although a parent may be positively acting, making positive acts in terms of how they treat their child, whether it's violence, whether it's deliberate exposure to drugs or to pornography, although there may be positive acts, the overall act is really an omission, a failure to act as a responsible parent. So the classic concept of common law omission, of course, is that there is no liability for an omission unless there's a duty. And I assume it's the same here, that we talk in first year criminal law about the baby drowning in the puddle, and if you see a baby drowning in a puddle, there's no liability if you just let the baby drown. I teach a lot of civilian lawyers, and they find this abhorrent because they have a duty of reasonable rescue in most civil law systems in Europe. So they find this reprehensible, but nonetheless that is where the basic line is in the common law tradition. Of course, if the baby is your child, then you owe a duty to the baby, and so at that point, failing to take the baby from the puddle becomes a criminal act, or a criminal omission. This was recently looked at in a Scottish case. Could you hit the enter again? Thanks. Bone against HMA, it's Her Majesty's Advocate. There's lots of funny terminology in this talk. Here, the charge was willfully failing to protect the child and ensure her well-being, as a consequence of which the child was caused unnecessary suffering and injury leading to her death. Bone was convicted of culpable homicide on this basis, which is manslaughter. Her boyfriend had beaten her child repeatedly over a period of time, and then one incident in particular was led directly to the child's death. So that was the charge, and on the basis of that she was found guilty of culpable homicide. And there was agreement between both prosecution and defence that what's being required to be shown is that it's a willful failure to protect, which is a willful failure to take steps that could reasonably have been taken to protect her. So a failure where there's a duty between a parent and child, a failure to take reasonable steps to protect that child in the face of an attack by somebody else will lead to liability, criminal liability on the basis of an omission. The conviction was actually overturned because of how the judge instructed the jury. So this is, the charge itself was fine. There was agreement as to how that should be applied, but in the particular case, the conviction was overturned. Why I'm drawing attention to that is that the issue was what reasonable steps actually meant, and this will sort of come back in later. And the appeal court said that the test wasn't what the objective reasonable parent would have done. The test was what was reasonable for that particular parent in that situation. In this situation, this woman was psychologically damaged herself, subjected to violence by the boyfriend, and physically of a much smaller stature. And so, in fact, it would not have been reasonable in those circumstances to expect this woman to have, the court doesn't say that, but that's what it implies, that it wouldn't be reasonable to have expected this woman to step in and intervene in the situation. So the Scottish courts have been taking a more humane, if you like, approach, not applying a high standard of reasonableness, but basing it on the specific circumstances of the accused, their psychological, their physical circumstances, the circumstances of the incident itself. So there is then obviously where there's a duty, where there's a duty to act, a failure to do so is an omission that leads to criminal liability. That doesn't really address the question of what happens when the child itself offends, because here the victim of the failure is the child, and the parent who doesn't, if you like, properly parent their child and the child then offends, the victim is still the child. The duty is owed to the child, not to the wider public. So that this type of liability won't actually, although this is the one that's sometimes referred to, this actually won't allow the law to hold a parent liable as a principal for an offence by their child, because the duty here is between the parent and child, not the parent and wider public. Another concept of omission in Scots law which seems more attractive as a basis for parental liability is where there's creation of a danger and failure to mitigate. So I don't know if that's something that you have. You have that here? Okay. So the classic case in Scotland is the farmer who set fire to a field of straw. The smoke obscures the road, and there's a collision between vehicles on the roads, and he's held liable for culpable and reckless endangerment of the lieges. So in 1982, the public in Scotland were still lieges, the public. So, but here there's a duty to the wider public, and a failure to mitigate the danger created by oneself gives rise to liability. But of course, it doesn't give rise to liability for the collision itself. It gives rise to liability for creating the dangerous situation. So again, vis-a-vis parents and children and their relationship to the wider public, although now we have a duty to the wider public, we don't have that connection between the actual incident and the creator of the danger as a principal actor in the incident itself. So again, that concept of omissions doesn't apply. Which brings me to another concept of vicarious liability, and this is where I think, although it's a little unusual and not subject to much discussion, if any, in Scots law, we actually can see a possible basis for holding parents liable as principals. And it's based on my other interest, other than juvenile justice, of international criminal law, which is what I'm actually teaching while I'm here. Under international criminal law, superiors and commanders are held vicariously, a form of vicarious liability for the acts of their subordinates. So they are held liable as principals for what their subordinates do. It's not true vicarious liability because there's some element of fault on the part of the commander or superior. The classic exposition of this is the Yamashita case, which a lot of you probably maybe have heard of. The Supreme Court in 1946, US Supreme Court in 1946, an appeal from the Military Tribunal. General Yamashita was in charge of the Japanese army occupying the Philippines and was held liable for atrocities committed by his subordinates on the basis that he had failed to control them. It's quite a harsh standard that the court uses, and some of the justices dissented on this basis, that it didn't require any kind of knowledge that his subordinates were committing atrocities. It didn't require any kind of willful blindness. In terms of the charge, all it required were that he, as commander, failed to control his troops, and when they committed an offence, he therefore was liable for it, as if he had done so himself. Over the years, Dave, could you hit the thing again? Thanks. Over the years, that has been softened by the international tribunals, and this is the formulation of commander superior responsibility that's found in the International Criminal Court statute. The underlining is 9. So, as you can see here, the forces have to be under his or her effective command, effective authority and control. There's a failure to exercise control properly, where there's knowledge or constructive knowledge that the forces were committing or about to commit crimes, and a failure to take necessary and reasonable measures within his or her power to prevent it. In other words, there has to be an element of fault on behalf of a commander or superior. It's not a strict, it's not true vicarious liability because it's not strict liability. It does matter how the commander behaves, him or herself. This, as I said, admittedly, this is not something that the Scottish courts have dealt with, but it does form part of Scottish law, since we have ratified the Rome Statute of the International Criminal Court, and expressly in that legislation, where we take universal jurisdiction over somebody, then we apply this standard. So that does actually form part of Scots law, and the UK Supreme Court has recognised it in a recent asylum case as a basis for assigning liability. So it's fair to say that it's part of our law, although we don't have many decisions discussing it. So my contention is that you can transfer these principles to the situation of a parent and a child where the child offends and the parent has not taken steps to prevent that offending. Similar to the creation of danger cases, the duty here by the commander or superior is to the wider community, and not to the subordinate, but the subordinate's act then will bring with it liability. In Yamashita, the court said the purpose of Commander Superior Responsibility is that without being restrained by a commander, troops will do what they want. That's inevitable. And I would argue that without parental guidance, children will do what they want. And in Roper against Simmons, I've forgotten which justice discusses the problem of the fact that children have lack of impulse control, that without certain parameters and guidance in place, they're likely to become involved in offending behaviour. And certainly there are plenty of studies that back this up. So the purpose behind this type of responsibility, and if you like, the ethos or the responsibility we place on parents are very similar. We have parental responsibility because parents are supposed to prepare their children for life in society. Where I think, and this is very much a work in progress, so I'll be interested to hear your comments. Where I think this becomes difficult when applying it particularly to children and parents who are in a sort of chaotic situation is this question of effective control, because obviously in situations where parents are, for example, have drug or alcohol abuse problems, it may be hard to say that a child is or is not under effective control. And there's also a problem that the child may not be under effective control at the time through no fault of the parents, but the question is how far back do you take it? At what point if the parents lose control at the age of 7 or 8 and the crime happens at the age of 13, are they still to blame? Or so there are issues particularly of causation and of that I realise need to be addressed and considered. What this also does, though, is it does recognise that there can't be automatic liability in this type of situation, and so there is a requirement of some kind of fault and knowledge on behalf of parents. So knowledge or constructive knowledge that something was going to happen, and in many cases that we see on the children's panel, I don't know if I said, I actually sit on the children's panel, that's one of the reasons that I'm interested in it. In the children's panel, a lot of the cases that we see are where the parents know there's an escalating behaviour cycle, more and more serious offending, more and more use of alcohol or drugs, failure to attend school and so forth, and even with social work intervention fail to do anything about it. And that is exactly the type of situation that can be covered here, where there is knowledge, or at least constructive knowledge, that the child is likely to commit a serious offence, but nothing is done. Now, it may be that nothing is done because there's been a loss of effective control, and in that case the parent would not probably be liable. But it tries to at least put some fault on the part of the parent as principal. It's also important, I mentioned the reasonableness of the intervention in the Bowen case. It's also important to note that what's expected of the superior is a reasonable act in the circumstances, necessary and reasonable. So again, given that Scots law would never, or has used this standard of what's reasonable for that person in those circumstances as regards omissions, it seems likely that the same standard could be applied here. And again, that would take into account the individual characteristics of the parent themselves, including, for example, something else that the children's hearing often sees is parents who themselves have been children before the hearing in their time. And because there is an issue, obviously, you'd almost have to build a defence in to say that if a parent who's being accused as a principal on this basis themselves was subjected to that type of parenting, then their culpability is also reduced, and so it goes and so it goes. So I recognise that there's a potential issue with that, a practical issue with that as well. I also realise that this could be seen as a regressive approach in terms of the fact that, well, in many different ways, and don't worry, I see some people going, what? I'll get to some of that later, but a regressive approach in terms of how we think about children and their autonomy, because the discourse in children's rights has grown to be that children are autonomous and that they have their own rights and they're not related to their parents in such a strong way. I would submit that in this situation, as long as the child is not being prejudiced by the legal relationship between parent and child, that really is unimportant as regards holding the parent responsible. Because child's rights and children's autonomy as regards their rights are to do with the child and what's best for the child, and the parent should be secondary in that circumstance. It does seem harsh to bring in a concept of vicarious liability, but we already have it in civil proceedings. In Scotland, a parent who is at fault, who is negligent, and whose child, because of that negligence, causes damage, can be subject to civil liability. And so it's the concept is already there within our system. It's just not being used within criminal law. So my contention is that this model does actually give us a theoretical underpinning to hold parents liable as principals for the acts of their children, but of course, just because we can do something doesn't mean we should do it, and there are a number of questions to be answered, particularly about what's the discussion of what's been termed responsibilisation. This question of holding children responsible for, holding parents responsible for what their children do. In Scotland, there is already something called a parenting order. Actually, I should go back. In the late 1990s, the New Labour government was getting tough on crime, tough on the causes of crime, and they introduced something called the Antisocial Behaviour Order. This is an order that's placed on someone, particularly young people and young adolescents, who are indulging in antisocial behaviour, causing fear and alarm in the community, vandalism and damage, basically, I suppose, out of control children. And what the Antisocial Behaviour Order is a civil order sought by the local government, but breach of it then is a criminal offence with criminal penalties. What can also be put in place is known as a parenting order. So if an antisocial behaviour order is put on a child or young person, the parents may also have an equivalent parenting order placed on them, which means they have to ensure the child doesn't offend again. If the child does act in an antisocial way again, both child and parents become criminally liable for that breach. And that is strict, that is proper vicarious liability, that is strictly applied. In England and Wales, they've had those since 1998. In Scotland, in 2005, they instituted a 3-year pilot project. During those 3 years in Scotland, one parenting order was made. One of the things that I need to look at, and I haven't found anyone who's done an evaluation of it yet, is why that was. Whether it was because the local authority didn't seek them or whether judges weren't granting them. But it seems as if that, although it wasn't particularly well thought of by people within the system. And it might be because a lot of kids who are indulging in antisocial behaviour anywhere in the children's hearing system, and so this would be an extra step that wasn't required. In England and Wales, it's been subject to a lot of scrutiny, and this is part of my research that I'm still looking at, but there obviously are a number of problems or potential problems identified with these orders. For one thing, there's a perceived and probably actual inequality in who is being subjected to them. Part of this is because local authorities have undertaken a process of putting families where antisocial behaviour orders have been given into public housing in one area. So rather than have them spread through the community, yeah, they're all in one area. That of course presents problems not only for those families in stopping the offending, because all of these adolescents are now all living next door to each other, but also then people within the community who have been there for a long time are not able to leave. And so it does produce, produces a number of social problems, but there is inequality of application of those parenting orders in England and Wales. There's also the problem that these strategies are being underpinned by stigmatisation and judgment, particularly of families who are who are subject to deprivation. And that it fails to promote prevention and focuses more on punishment. So it's coercive rather than supportive. And it's unrealistic, and therefore it's unjust to criminalise parents for the actions of their teenagers. I have sympathy with a lot of these criticisms as regards that type of strict liability. I think actually though using this model avoids some of those problems. If you think about inequity, well first of all, inequity in application may happen anyway, but I don't feel that this theory necessarily lends itself to inequity per se. For example, this requirement of knowledge or constructive knowledge that the child was likely to offend. In that situation, it's likely actually that the more sophisticated parent, the more educated parent is more likely to be shown to have knowledge or constructive knowledge that the child is likely to offend than a parent in other situations who may not have that same level of education. Similarly, as regards it being unrealistic or unjust to impose strict liability, it is. But here, because we have this requirement of reasonable measures and effective control required, it's more likely that parents who are doing their best but because of surrounding circumstances are not able to parent in the way that that society wants will be able to will be excluded from culpability on that basis. It doesn't change the fact that it's still based on, if you like, a stigmatizing and judgmental attitude towards parenting, but where you land on that spectrum, I think, kind of very much depends on where you land on the political spectrum too, but it's an aspect of this that I want to look further at. On the flip side of that is there are a large number of studies that conclusively confirm that children who offend are put at risk of that offending because of parental behaviour. The question is, how culpable are the parents for indulging in that kind of behaviour in the first place? And as I've said, the Scottish courts do tend to take a sympathetic approach to parents in these type of omission situations, looking at what the individual circumstances of the parent are themselves rather than what the reasonable parent ought to have done in the circumstances. So in a way, using this theory of liability, we're really looking at the most serious situations of parental failure to act in the face of first of all, ability to act and overwhelming evidence that they ought to act. That's really the type of situation that I envisage this would apply to, rather than being used as a basis for lesser incidents and situations where it's not clear how much fault can be actually placed on the parent themselves. So that's it. I realise that I have not fully articulated conclusions, but that's where I am with my research at the moment, so I'll be welcome to take questions. Yes?
Yes, I'm totally fascinated.
Oh, sorry.
You can sit down, Bill. Turn off the back.
I'm totally fascinated with the attempt to take this on.
Turn off the back.
And I think I'm intrigued by using the Article 28 military framework. I would expect that if you had this discussion in other places in the United States, two major things would be pointed out, neither of which I don't know if anybody can solve. Under the military framework analysis, there is this assumption, I guess, that trying to analogize the child to a military soldier has some obvious difficulties. The soldiers are presumed there's training, there's things that where you have a common foundation of compliance, even though they, if left alone, they will go nuts. So I'm willing to agree that both soldiers and children left alone will go nuts. I cannot dispute you on that. But the idea that what makes it fair to hold the commander responsible it has something to do with what it means to be a soldier. And all children don't have that equal presumption of training or structure. And I just think that maybe it's not necessary to your analysis, but I certainly think the difference should be, adequately explained. The more interesting part is something I found interesting in our own jurisprudence. I even have a case about this in my case book that is really totally wrong in terms of legal analysis, but a court in this country, one court in this country that looked at this problem, where the legislature tried to narrowly tailor a statute that should have probably been acceptable in policy, not heavy punishment, the idea that it's something where the parents should have been in control, kids breaking out and riding snowmobiles was the case. The kind of thing that you would expect parents to be able to regulate, and not really punitive, calling it punitive, but really very low penalty. The court fought against the validity of such a law, even when the legislature did, I think, all it could to carefully craft a narrow tool, which indicates to me that the court would never permit the vicarious liability. They would come up with some other reason rather than attach vicarious liability, even if they had to make it up, even if it defied all conventions of what we found to be acceptable as vicarious liability in our jurisprudence. And so, at the end of the day, even if we were to work on all the problems in the framework, courts in this country have proved reluctant to find any framework valid, even if they have to lie or mislead as to the component parts to do it. And so, it's great to come up with a framework, and you probably are onto something to link it to these ideas, but what if courts just refuse to embrace it? Because somewhere they think that once we make parents liable under any theory, then how are you going to sort of stop it? So they use it like the causation valve, which is when it's causation, when we say it stops. Just embrace that last legal tool that a court has. And really what we're doing is we're drawing a line, because that ultimately is our job, even if we don't articulate it with the legal principles that we say we're using. So I think if you run into with the jurisprudence here on this.
I think to take your second point first, that's an interesting point to me that this has been tried here, and I haven't done a comparative study so far, apart from within the UK jurisdictions. So it's interesting to me that it's been tried here, and the courts are the ones that have put up opposition to it. It may be that, as I said, the Scottish courts have been reluctant to apply parenting orders, so it may be that the same thoughts and the same feelings would apply to judges in Scotland too. It's certainly possible. In addition, it's also quite possible that, as I said, because the courts have taken this view when looking at parent and child situations of what's reasonable for that parent in those circumstances, not an objective reasonable parent. Again, I think courts will find ways of not applying this standard. But my purpose wasn't really to come up with a theory to hold parents liable. Is to explore, and initially it was to explore and negate the call that comes up every so often when we see one of these terrible cases that parents should be held liable. But what I found was, when I started that investigation, that actually I found ways in which this particular theory would theoretically work, if not in practice. So I mean, it's a point well taken that it may not have practical effect, but I suppose I wanted to test the theory and then go on to look at policy and other reasons why, and certainly haven't finished with it, why it may or may not be useful or desirable to do it. Your first point about equating children to troops, I mean, I think my focus, that is interesting, my focus has been on the parent and the commander and the similarities or differences there, rather than on the child vis-a-vis or compared with a member of the military. I suppose that I would say that I think that, you know, it's not impossible to draw that distinction, even though a soldier with training and education and so on is in a different position than, say, a 12-year-old child. But in fact, it's almost that given the 12-year-old child's position, it's even more important that the superior be in charge of what's going on. And if they are willfully failing to do that, then perhaps they should be held to play some part in contributing to the outcome of the child's offending. I realise too there are and I meant to talk about this and didn't, that there are huge causation issues here, and so again another practical litigation issue is proving that link between the parent's acts and the child's offending.
If I'm the lawyer representing a parent in a two-parent household, one of my defenses, of course, is going to be, I did everything, my client did everything he or she could, but it's the other parent's fault.
Yeah.
And is that a possibility? And then, is there a concern you might have that there'd be more prosecutions against single-parent households because it's easier, that defense doesn't come up? And because one parent is obviously the only one there and it's asked to do a great deal more.
Well, I suppose in terms of it being perhaps negatively impacting on single parents, what I would say is that a single parent is more likely to meet the test that they did everything that was reasonable in the circumstances than when you have two parents who are co-parenting within the same household. So I don't necessarily think it follows that that would happen. It is interesting, this question of the two parents pointing the finger at each other. In the Bone case, that's exactly what happened, that he actually initially said that she had done certain things to the child, and this is quite common. It does present a problem for the prosecution, and again I suspect that this would not be something that would be used in many cases. I think this is where we're looking at serious issues, but that's actually a good point. It's a real practical problem. Yeah.
Sort of following a little bit up on the analogy between the military and the family, because it seems a lot of the theoretical underpinning rests upon that. One difference strikes me as the military is somewhat total for the soldier that's in it, but as you kind of alluded to in your talk, the parents are just one of on the spectrum of people that are acting in loco parentis. So do you think your theory of liability that you're developing here could also be used to go against teachers in schools that were on some kind of constructive notice, priests in the parishes that were on some kind of constructive notice? Anybody that's acting in loco parentis, it seems that the analogy would hold just as strong. Is there something, that's particularly a reason why you would focus on the nuclear family, even grandparents or anybody that's raised them? It seems like any of those would work.
I think I've focused on the nuclear family, or people who are what we would call relevant persons. That is, they're in loco parentis in that they are who takes care of the child on a daily basis at home. Primarily because our system focuses on the unit in terms of looking at prevention. So when the children, for less serious offences, come before the children's hearing system, the child is made subject to a supervision requirement, but it actually is the parents and the immediate family who are the ones that have to comply and take charge of the situation and so on. So suppose that my my theory at the moment is based on that conception of who is in charge of a child's upbringing, who is responsible for a child's upbringing. And it's a good point that certainly, obviously, people like social workers, like teachers who are aware of a situation and do nothing about it, certainly are usually subject to disciplinary action if something goes badly wrong. But holding them responsible as principals, I feel, is a step too far, because they're not the people who are responsible on a daily basis for the child and their behaviour. Even though they may have an impact on...
They could be there daily, right?
Yeah. That's true.
A couple of quick things, and I'm going to say them and then probably leave because I have class, but I had a similar reaction because you started with the story about the councils and how they're people drawn from the community, and the community is responsible for dealing with the child's situation and reacting to it. But then the theory focuses on the parental liability. So in a way, they're going in opposite directions. Like, is the fact that people were so upset about, what happened in the case that you started with the 3 kids, 14 and 16 or whatever, were people pushing or questioning parental liability because society's sort of giving up its community role in regulating, the behavior of the child? And then the other just quick thing is, I was thinking about the effective control standard and where it comes from, and if it comes from principles of state responsibility and effective control versus overall control, like in the Tottage case versus the Nicaragua case, and to what extent that works for individual people, which, obviously the International Criminal Court chose to use that standard, but it might be interesting, at least in this context, to come up with an example of effective control. Like, here's a situation where a parent could be said to have effective control over a child. What would that look like? In fact, and is it too high a standard for any fact situation?
Okay.
That was a question I kept thinking, because maybe it's because I have a 2-year-old, but I just think like overall, maybe I have overall control. Maybe I have general control about what happens with her, but can I stop her from having a temper tantrum? Yeah. Maybe not. So
to answer that point, I think it is a really, really high standard. I suspect that it would be the rare case where it would be met. I'm glad for that. I didn't want to give the impression that I want to be able to find parents liable for the acts of their children. I think I don't think it's a desirable thing to go down that road. However, I felt that somebody had to actually test it to see, because there's always a clamour within the media and within the public for it to be done. So I felt that it's a useful exercise to see. I think it is a really, really high standard. I saw one case personally, so this is anecdotal, on the children's panel, where a child was offending in terms of assaulting other children at school, relatively minor assaults. The child did everything else it was supposed to do. She was supposed to do. She went to school. She did her homework. She carried out every other task her parents asked to do around the house, but she went to school and she beat these other girls up. And it turned out that at home, her parents were not really very bothered by this behaviour, that the school was telling them it was happening, and they didn't care. They said, well, she doesn't like them, and they call her names, so she's entitled to physically attack them, and we're not going to get involved. That was the gist of it. To me, that child was within effective parental control, and they knew that the child was likely to assault these other girls, and they were failing to do anything about it. That's a type of case on a minor level. Now, with more serious crimes, the chances are the child is out with effective parental control. So it makes this less useful, because it's not likely to be used for minor crimes. The question about individual responsibility, I think it's become quite well established that this is a theory of individual vicarious liability, and it has nothing to do with states. It can be applied outside the military context where you have, I mean, I didn't put it up, but the other part of the article is a superior subordinate role outside the military context. And it can be applied there too. So it could be applied to prison, the police force, which I realise still have a quasi-military. But anywhere where someone has a responsibility to be in charge of somebody else, and where the other person is, goes out with that and commits an act, then I think it's quite settled that there is individual liability. And in Scots law, as I said, we have already got vicarious liability in civil matters where a parent is negligent and their child damages property, say. The owner of the property has a right in, well, we call it delict, but a right in tort against the parent. So it's not, for Scots law, it's not a huge leap to say we're imposing vicarious liability on a parent, because we actually do have it in the civil law system, although, of course, because it's criminal law, you have to be a lot more careful. Yeah.
I have a little question, maybe a broader, completely confusing question. The little question is, I was just curious in trying to figure out the subjectivity issue with the parent. If a parent were addicted to drugs and doing drugs, as you said, is that a mitigating factor or an aggravating factor? Is that evidence of a parent's neglect, or is that an evidence of a parent?
And that's sort of one of the difficulties that I think this does present that I haven't ironed out yet. In one way, I would suggest it's a mitigating factor, in that if a parent has a misuse problem, then the standard of what's reasonable for them to do, the ability of effective control, the constructive or actual knowledge of what's going on would likely be reduced. The problem, of course, is how do you use, if you like, the intoxication defense model, where if you say, well, it's voluntary, then it's not a defense. So there's definitely an issue that needs to be ironed out there, and I haven't got an answer to it yet.
I mean, I imagine as a practical question, that will be a very common phrase, and I'll bet more often used in an aggravating way than in a mitigating way, I fear. But I think it highlights some of the challenges of the sort of subjectivity of it. My other question is a little bit, I don't know if it's even going to make sense, but it occurs to me that the parenting failure can come in both as an omission or as a commission. There is the things like beating of a child, things like that, which one could argue is shaping a dangerous individual, and then there could be the well-meaning parents who have a child who, for one reason or another, chemically is out of control, and they fail to adequately step forward and do something. And I'm wondering if it would be valuable to separate these two failings, and whether you need a theory that is based on omission. Does reckless endangerment at some point get some of the more egregious behavior? If a parent or is the causation proof so difficult that it's impossible? To me, there's an attraction to going after the commission offenses of the parent more than the omission offenses. And I'm just curious if we're creating this theory of liability because of a proof problem, or if there's a broader sort of theoretical reason for it.
Yeah, no, it's a good point. I suppose when I had looked at Scottish rules on things like reckless endangerment, I was looking at who is a duty owed to by whom, and it seemed to me that in terms of using a positive model like reckless endangerment or culpable and reckless injury or whatever, however you want to phrase it, it wasn't clear that you could actually link the Parents Act to the Child's Act in a sufficient way to show, as you point out, causation. And I don't think causation's cut and dried with this either, but I felt at the time that omissions were, I suppose I was looking at it in that the whole parental failure is an omission. It's an omission of fulfilling your duty or your responsibilities as a parent, rather than you hit the child, that's a positive act. It may be, but it's actually a failure as a parent. So I suppose that was where I was taking it from. And that was why I went down the omission route, because looking at other theories of participation, it didn't fit into any of those regular positive act participation models. I didn't really feel that there was enough connection between the parent and the victim to use the type of theory that you're suggesting.
We're coming to the end of our time. I think there are two people who've had their hands up.
Yeah, I was
so
going to say
yeah.
Kathy had her hand up for
So
ages.
if we could have two quick questions, one after the other, and then you can give your final response, and then we'll have valedictions and go.
Kathy, did you?
Yes, my perspective is a little bit more from social policy, and I find your use of military responsibility extremely interesting, and looking at it from also a parental perspective. When you've got a child who is in the school system and in daycare, and this is one of the big discussions in our society, especially with bullying and also shootings in the schools, is that the kids who, and what may be an interesting angle, is maybe not the kids who don't make it up through the higher tiers of your model, but taking a look at the responsibility, can a parent hold the school system, the social services sections liable, because as you mentioned, kids who are in trouble have a history, and they usually have a very early history, and a history that is not always addressed by the system. So again, looking at, okay, if you can hold a parent responsible for poor parenting, can you hold the school system, the principal, responsible for looking the other way? Can you hold, and so I find that very fascinating and would love your thoughts on that.
Yeah, I mean, that is interesting. Actually, it reminds me...
Or even like the company, can you hold the company responsible for not paying enough salary to their lower level wage employees while they're making a lot, not having health insurance, and then can you move it up through the political system?
Yeah.
In the US, that's what I found interesting.
Well, it's actually, that's an interesting point. It reminds me of a series of decisions in the English courts, and I think one in the Scottish courts, where children who have been put into care, whether it's with foster parents or in children's homes, have been able to sue, and their natural parents have been able to sue on their behalf the local authority where those children have not been cared for properly. And I think maybe that fits into this idea that the person who is in day-to-day charge, if you like, has this responsibility, and if they fail to fulfill it, they've attracted liability. How it applies, if you like, upwards and outwards in your model, I think is similar to your point about are the schools liable, who else is.
Because kids are not under, especially at this age, under a parent's control,
Yeah.
especially complete control for that much of the day. They're in school so much of the day, and there's a lot that goes on in school. And the school is supposed to be the social support structure for when these troubles are occurring.
I have to say that I think at home there's been a real reluctance to go down that road at all. Teachers don't want to go down that road.
Right.
And generally, I don't think law or policy makers have taken that step. We're pretty much in a situation where obviously no harm needs to come to the children while they're at school, but at the end of the day, the person that lays down the law is the person at home, and that's the person that's where the buck stops.
Right.
Okay,
And that's where
that's
so the very last question.
Very last question.
Thank you.
I'll try to make it very quick, but it just seems, following on David and Yenke's point, I mean, it seems there's a spectrum of parents who would possibly fall within your framework, but there's only going to be a very narrow band that are going to satisfy the causation, effective control, and so forth. And I just thought it might be interesting to do sort of an empirical review of the different types of profiles. And that gives rise to the question of, if there's a particular profile that is most likely to fall within the band that you could successfully prosecute, is that the kind of profile that is, one, likely to be modified by this kind of law, and two, likely to have the kind of criminal culpability that you would want to prosecute them? Because it seems to me that the profile might be the parent who are struggling to maintain some effective control, or trying to be responsible but are losing control, and then finally the parent commits a crime, and they're the most likely to be successfully prosecuted, as opposed to the parent who's just abandoned their kid or is abusing their kid, and they're less likely to be successfully prosecuted, although they might be more morally culpable.
Yeah, I mean, I would disagree in that I think the factor that the parent has to take what's necessary and the steps that are necessary and reasonable in the circumstances excludes the parents that are trying but failing. I mean, I think if parents are trying, then they probably are taking reasonable steps. And again, given the jurisprudence in other areas in this or other types of parental responsibility cases, is looking at the parent in their own circumstances, not an objective reasonable parent. So I think it probably wouldn't cover that kind of person, but I think it would actually be good to sit down and look at who would fall, and it's certainly something I'm going to do, look at who falls into this, and then therefore is the public interest. As I said, I personally don't think it's a good idea to do this, but felt that it needed to be explored. So hopefully I'll find lots more reasons why I shouldn't apply my theory.
Well, thank you very much. That was a wonderful and stimulating talk. And just before you leave, on behalf of the University of Baltimore, I want to give you a present, which I may have given you already, so you get two.
It doesn't leave them.
Here you are.
Thank you very much.
This is the uniform of the University of Baltimore Center for International Comparative Law.
Thank you.
Usually I give people a choice, but I just gave you, I thought you didn't want it
Thank
next
you.
time.
Thank you. My favorite color as well. So
Good,
thank you very
good.
much.
Well, thank you for being part of our team this year.
Thank you for having me. I really enjoyed being here. And I'm here for another week and a half as well. So
Good.
a week or
Well, we
so.
can have less formal celebration. And thank you to our audience.
Thank you. Thanks all for coming.